2013 was actually a particularly busy year for unfair dismissal law, so we have got some interesting decisions to tell you about. But first of all, a reminder of some of the basic rules. In order to qualify for the right to claim unfair dismissal, an employee has to have a continuous period of employment. This is 1 year if the employment began before the 6th of April 2012, but 2 years if the employment began on or after that date. So we're very close now to the point where you need 2 years in order to be able to claim unfair dismissal.
Now, continuity is determined by statute and not by the employment contract. Generally speaking, a break in employment that is less than 1 week will not break continuity of service and vice versa. However, a longer gap will not break continuous service, where the employee's absence is as a consequence of sickness or injury, on account of a temporary cessation of work, or in circumstances such that by arrangement or custom, they are regarded as continuing in the employment of the employer for any purpose. Okay, so let's look at the first case, Welton and Deluxe Retail trading as Madhouse. The EAT held that an employee who took up an offer of a new job with the same employer after his workplace closed was continuously employed, despite the fact that there was a gap of more than a week before he started the new work in the new location. Mr. Welton worked for Madhouse at their Sheffield store from 5th of January 2009 until 23rd of February 2010 when the store closed. During the week commencing 28th of February 2010, he accepted an offer of employment to work at Madhouse's Blackpool store. He started working in Blackpool on the 8th of March, so that was clearly more than a week after the end of his last working week in Sheffield. But his new employment didn't last very long. In fact, it ended less than a year later, and he brought unfair dismissal proceedings against Madhouse.
So the first question for the tribunal was whether he actually had a year's continuous service. His employment at the Blackpool store was less than a year, and he could only bring the claim if he could add that to the previous service at the Sheffield store. Now, there'd been that gap in between the two. So the tribunal actually decided that he couldn't bring the claim because there was more than a week's gap between the two jobs. Mr. Welton appealed to the EAT, which many of you will now know from these previous events that's the branch of the High Court which actually deals with appeals against decisions of the employment tribunals. Now, they said that the tribunal had got it wrong, and they gave two reasons. The first was that they said there'd actually been less than a week if you take the point at which the chap accepted the offer of work, even though he didn't actually start the new job for more than a week. So there was a contract of employment in place between the parties. But they also held, perhaps less controversially than that this was, in any event, only a temporary cessation of work.
So what's the practical point that we want you to take away from this case? Well, first of all, it shows just how hard it is to break someone's continuity of employment, and it's irrelevant what the contract actually says. In this case, the contract said that Mr. Welton's previous employment didn't count, but the EAT, as we've heard, said it did. And there's another point you need to appreciate. The test of whether there's been a temporary cessation of work is an objective one. It doesn't matter that the employer and the employee thought that the break was permanent at the time that the employee was dismissed.
Right, moving on to another point. It might be a bit obvious to say it, but if somebody wants to claim unfair dismissal, obviously they have to be able to show that they've been dismissed. Now, this sometimes comes down to the question of whether they've been pushed or jumped. Usually it's fairly clear, but it can be a bit blurred if, for example, an employee has been given a choice as to how the employment is terminated.
Okay, so let's look at the next case, Francis and Pertemps Recruitment Partnership. Mr. Francis was employed by Pertemps, which was a temporary employment business. His employment contract specified that he was to work for a particular client as an administrative assistant. The work which he did was transferred to an alternative location and he was no longer required by that client. His contract didn't make any provision for him to be reassigned to anybody else, and Pertemps offered him a choice. He could either be given 2 weeks' pay, during which time he would remain employed and the company would continue to look for alternative work for him, or he would be given 2 weeks' notice pay and a redundancy payment. And whilst he initially chose the first option, he then changed his mind and decided to accept the redundancy payment. The idea being that he could then claim certain benefits which he wasn't entitled to while still employed. Pertemps then wrote to him confirming that his position was redundant and that their letter should be treated as formal notice of redundancy. Despite the fact that he'd chosen the redundancy option, Mr. Francis then claimed unfair dismissal in the tribunal. His claim was initially rejected as the tribunal said that there had been no dismissal. They said that the parties had mutually agreed to terminate the contract. However, once again, the EAT has disagreed. They said that the two options were both initiated by Pertemps, so it was their decision to make him redundant. They also found that there was no alternative work for him to do, so both options would inevitably have resulted in his dismissal. The company intended to dismiss him, whichever option he chose.
So what this case demonstrates is that if an employee is given a choice, it's got to be a genuine choice. The courts are generally reluctant to find that a termination has been mutually agreed. Now, you might think this actually was a harsh decision against the employer, and I tend to agree. But the message you need to take is that if you decide to give employees the option of taking voluntary redundancy, this doesn't actually mean that they can't subsequently challenge it and claim an unfair dismissal. And that's why many employers still require employees to sign compromise agreements, now called settlement agreements, in so-called voluntary redundancy cases.
Now, where an employee successfully appeals against dismissal, it's normally the case that that wipes out the dismissal. But the next case, Piper and Maidstone and Tunbridge Wells NHS Trust, demonstrates the importance of the specific wording of your disciplinary policies. The Trust's contractual disciplinary policy stated that in exceptional circumstances, management could take the view that even though a proven disciplinary offence might warrant dismissal, the organisation and the employee would be best served by action short of dismissal, for example, demotion or transfer to another role without pay protection. However, it went on to say this: if the employee does not agree with this course of action, dismissal is the only alternative. The policy also gave a right of appeal against dismissal. Following an incident with his manager, Mr. Piper was dismissed for gross misconduct and he appealed. The Trust decided to substitute for dismissal a final written warning and a downgrading of his role, which involved a reduction in pay and transfer to another hospital. Mr. Piper sent an email informing the Trust that he was not prepared to accept what he called the offer of re-engagement, and he made a claim for unfair dismissal. The Trust argued that the effect of the successful appeal was to remove the earlier dismissal and demote him instead, and they argued that rather than accept that disciplinary penalty, Mr. Piper had resigned.
Well, the Employment Tribunal agreed with the Trust. They pointed out that the Trust had reserved the right under their policy to demote as an alternative to dismissal. But here again, the EAT said that the Tribunal had got it wrong. The terms of the policy stated that the Trust's decision to substitute a lesser sanction couldn't take effect unless Mr. Piper agreed. So in the absence of him agreeing with it, the dismissal stood. So what's the practical point here? Well, actually, this is one of the best lessons you'll learn all morning. Get the wording right. The policy shouldn't have said that the employee had to agree to be demoted. If the policy had actually said the right was reserved as an alternative to dismissal to demote, this case couldn't have been brought. So what's the best way to get the wording right? Who do you pay to get the wording right? Those evil lawyers that you need so much. So get us to check your handbook, get us to check your policies. New cases come up every year like this one. if you don't keep the wording up to date, you may well regret it later.
Now, we said earlier that someone can only claim unfair dismissal if they've actually been dismissed. But of course, that's not strictly true in the case of constructive dismissal. A constructive dismissal occurs where the employer does not dismiss the employee, but the employee resigns and can show that they were entitled to do so as a consequence of the employer's conduct. Employees making this claim often allege that their employer has breached the implied term of mutual trust and confidence. In Flexman and BG International, Mr. Flexman was employed as an HR executive. One of his colleagues anonymously reported to a senior manager that his LinkedIn profile contained inappropriate confidential information. Mr. Flexman's line manager left a voicemail message requesting that he remove the offending material. His view was that the profile shouldn't contain any information about the company except job titles and dates. Now, Mr. Flexman was reluctant to comply, and rather than remove the information entirely, he simply restricted access to the content of his public profile. On his return to work, he was informed that the company was taking disciplinary action against him, and a disciplinary hearing was held and then adjourned. A few days later, the HR manager informed Mr. Flexman that she would meet with the person chairing the hearing again to decide if the hearing needed to be reconvened or if she now knew enough to make a decision. Mr. Flexman complained that matters were being unreasonably delayed. He also pointed out that it was contrary to the company's disciplinary process for HR to be involved in reaching the final decision. The company was advised by its in-house lawyers that in view of Mr. Flexman's concerns, the process should be started all over again, with a new person chairing the hearing and a different HR advisor. Now, Mr. Flexman objected because he just wanted it all over with, as quickly as possible, and he raised a grievance. There were further delays after that, culminating in him being informed that the company would continue with the process originally started, albeit with a different HR manager. And eventually he resigned.
What a palaver. I hope you all followed that. The end result, of course, is that Mr. Flexman claimed successfully that he'd been constructively dismissed. The tribunal found that he'd resigned because he'd lost faith with his employer's ability to deal fairly with the disciplinary and grievance procedures. And the cumulative effect of all those delays and reversals in carrying out the disciplinary process amounted to a breach of the implied duty of trust and confidence. So what do you take from this one? Well, that duty of trust and confidence, which is implied into all contracts of employment, can indeed apply to any aspect of employment, including the way that you operate your policies and procedures. Excessive or unnecessary delays and failures to comply with your own procedures can all amount to a breach entitling the employee to claim constructive dismissal.
Okay, we're going to look at another case on constructive dismissal. In Wright and North Ayrshire Council, the key issue was what actually caused the employee to resign. Mrs. Wright was employed by the council as a care-at-home assistant. After raising 3 grievances which were not properly addressed by the council and having been falsely accused of theft, she resigned and claimed that she'd been constructively dismissed. Whilst the tribunal found that the council had fundamentally breached the employment contract, it held that she'd not been constructively dismissed. Although the tribunal found that the council's breach was one of the reasons she resigned, it found that she was struggling to cope with looking after her ailing mother and husband whilst continuing with a full-time role, and that was the effective cause, in other words, the main reason for her resignation. She appealed to the EAT, and you may or may not be surprised to hear that they decided that the tribunal had got it wrong. It was sufficient that the council's breach played a part in the dismissal, so she could still claim constructive dismissal.
So what's the practical point on this one? Well, the key point, I think, is that the EAT's decision, although more for lawyers than employers, is that an employee who resigns might be doing so for more than one reason, Some reasons might be work-related, some might be personal, as here. But the point with Mrs. Wright is that she would actually have continued working despite the personal pressures in her life if she hadn't been treated in the way she was by the council in this case. So she decided to resign and devote her time, yes, to looking after her seriously ill family, but that wasn't the reason she resigned. It certainly wasn't the only reason she resigned, and it didn't let the council off the hook.
When an employee has been dismissed, it's for the employer to show that the dismissal was for one of 5 potentially fair reasons. And they are conduct, capability, redundancy, illegality, or some other substantial reason. In Tansel and Henley College, Coventry, among other things, the employee claimed unfair dismissal when his fixed-term contract wasn't renewed. Now, non-renewal of a fixed-term contract counts as a dismissal for the purposes of the Employment Rights Act. But was it for a potentially fair reason? Well, the college argued that the reason for the dismissal was redundancy, but this was disputed by the employee. And the tribunal shirked the issue, holding that the employee's employment had been terminated simply because the fixed-term contract had expired, and they said that no other reason was needed. Well, not for the first time this morning, the EAT said that this was incorrect. The tribunal had confused the mode of dismissal with the reason for it and had failed to identify the true reason for the employee's dismissal. So the case has had to go back to the tribunal to be redetermined. Why have we included it today? Well, essentially it's to warn you that just because you've got an employee on a fixed-term contract, it doesn't mean they can't claim unfair dismissal if they leave when that fixed term expires. Failing to renew a fixed term is still a dismissal, and you still have to have a fair reason.
Okay, if the tribunal does decide that the reason the employee was dismissed is one of those potentially fair reasons, the next step is to decide whether the decision to dismiss was actually fair. And this is where procedure is so important. One issue that crops up from time to time is whether an employee facing possible dismissal has the right to have their solicitor or possibly a barrister actually represent them at the internal disciplinary hearing. There is such a thing as a right to a fair hearing and a fair trial under Article 6 of the European Convention on Human Rights, and that's what's usually cited when this sort of request is made. And it's of particular relevance to public sector employees because their employers actually have an express duty not to act in a manner that's incompatible with convention rights. But it is also an issue for private sector employers because employment tribunals are themselves under a duty to apply the convention. So let's look at this next case, Ministry of Justice and Parry. Ms. Parry was employed as a district probate registrar, which is an office to which appointment is made by the Queen, notionally anyway, upon recommendation by the Lord Chancellor. She was dismissed following allegations of bullying, and she appealed, and she asked to have her lawyer present at the internal appeal. The Ministry of Justice refused. It went to an employment tribunal, and they decided that refusing to allow her to have her lawyer present was a breach of Article 6 because they were persuaded by her at the tribunal that her dismissal resulted in the Lord Chancellor's automatic recommendation to the Queen to remove her from her post. In fact, they went further. They accepted her evidence that the Employment Tribunal accepted her evidence that the MOJ's decision to dismiss her would inevitably prevent her ever working as a registrar again. So the MOJ appealed to the EAT, and again, not for the first time this morning, the EAT said that the tribunal had got that wrong. There was only a right to legal representation if the outcome of the disciplinary hearing would definitely determine whether the employee would continue to practice their chosen profession in the future or not. And despite the tribunal's decision to the contrary, there actually was no evidence to that effect. Now, it's reasonably reassuring, I think, for all of us who are employers, particularly if you don't fancy the idea of lawyers turning up to your disciplinary meetings. There had been a number of cases, including ones we've mentioned in previous years here, particularly where teachers and doctors have been concerned, where a right to legal representation at an internal disciplinary hearing had been successfully claimed. The question was it going to go beyond that? Was this something which anybody in employment was going to be able to claim, because they would say, well, I've lost my job, nobody's ever going to employ me again, it's for dishonesty or whatever. Now, in most professions where this is likely to come up, there will actually be a separate hearing before the relevant professional body, and that's where the individual's professional future is going to be decided. Even here, where this wasn't strictly the case, the argument in favour of legal representation failed. So it looks as if the courts have now pretty well decided that having lawyers present at internal meetings should be very much the exception and certainly not the norm, which I think 95% of people in this room would probably think was a good thing.
Okay, while we're on the subject of the Human Rights Act, Article 8 establishes that everyone has the right to respect for his private and family life, his home and his correspondence. Now, we've already looked at a case involving LinkedIn, and with the rising use of social media and CCTV use, the courts are having to find a balance between the employee's right to privacy and the employer's right to protect its business interests. Last year, we had the case of City and County of Swansea and Gale, which looked at the issue of whether covert video surveillance breached the employee's right to privacy and rendered his dismissal unfair. Mr. Gale was playing squash at a sports centre when he was supposed to be at work. The employer had been tipped off by a fellow employee who said he'd seen Mr. Gale playing squash between 4:30 and 5:30 p.m, but he'd not actually clocked off from work until 5:43 p.m. About a month later, Mr. Gale was seen again at the local sports centre, again during working hours. And on this occasion, he had the nerve to contact the office and leave a message pretending to his manager that he was at work. The council decided to engage a private investigator who covertly filmed him outside the sports centre on 5 subsequent occasions during working hours. And it might not surprise you that he was dismissed. But what might surprise you is that he then claimed unfair dismissal. And I'm sure what will definitely surprise you is that the Employment Tribunal upheld his claim. They found that the council's investigation was too thorough, and that the use of a private investigator was an unjustified interference with his right to a private life. Well, you might be relieved to find that the tribunal's decision was yet again reversed. But it's important to have regard to the reasons in this case. The video evidence was all taken in a public place when Mr. Gale emerged from the sports centre. He had no reasonable expectation of privacy in those circumstances. He was playing squash on his employer's time, and his employer was entitled to know where he was. So a balancing act also had to be struck, and a fraudster could not have a reasonable expectation of privacy. And this case resonates with the emerging case law that we are seeing in relation to employee misuse of social media, in which the courts and tribunals are taking dim view of an employee's suggestion that their activity on social media has some sort of absolute protection under the Human Rights Act. What is clear is that employees should have no real expectation of privacy if they are engaging in misconduct. In this case, the use of covert surveillance probably was unnecessary because there was sufficient evidence already available. But we're relieved that the argument that an overly thorough investigation will make a dismissal unfair hasn't got out of the blocks.
Okay, so we're still looking at when a dismissal is fair and when it's unfair. In cases where the employee has been sacked for misconduct, like in the last one, the tribunal will look closely to see whether the employer carried out a reasonable investigation and that it was entitled to conclude that the employee was guilty of the misconduct in question. So the usual argument is that it's not thorough enough, not that it was too thorough. And that's the position in Stewart and London City Airport. Mr. Stewart was a ground services agent. He was sacked for allegedly going to a duty-free shop and taking goods without paying for them. He claimed that what had happened was that a friend had beckoned him over for a chat while he was in the queue to pay for the items, and that he'd unknowingly crossed the threshold of the shop. A witness, however, who didn't know him at all, suggested that he had in fact tried to conceal the items in his jacket. Now, that witness wasn't actually present at the disciplinary hearing or indeed the appeal hearing, but the airport accepted her evidence. They ignored Mr. Stewart's request that they obtain the CCTV footage and that they take witness statements from his friend and also from the shop assistant who was on the till. So he didn't do any of those things. When it went to a tribunal, the tribunal found in the airport's favour. But once again, it went to the EAT, and the EAT said that was wrong. They said that the airport's failure to look into this additional evidence made the dismissal unfair. Now, I'm glad to say that it doesn't stop there, because the airport weren't happy with that, and they appealed as well, and they appealed to the Court of Appeal. And the Court of Appeal has now restored the Employment Tribunal's decision in favour of the airport. They said, well, the airport looked at the evidence that they had there, and they were reasonable in concluding that they just didn't believe the employee's explanation. That he genuinely didn't realise that he'd left the confines of the shop. They did find that that was untruthful. They were happy to rely on the witness who'd seen him try to conceal the items in his jacket. So, having taken an adverse view of his credibility on that important issue, there was no need for them to look at CCTV footage or to speak to other witnesses. So, what do you take away from this decision? Apart from the fact that the EAT doesn't always get it right either. Well, it shows that you don't have to go to the ends of the earth to investigate misconduct. Allegations don't have to be proved beyond reasonable doubt. That's a criminal test. These allegations have to be proved on the balance of probabilities. Now, having said that, it's very important to recognise that the more serious the allegations, the more serious the consequences for the employee's reputation as well as their job and their career, the more thorough the investigation should be. But in a standard misconduct situation, where there is sufficient evidence pointing to the employee's guilt, it really isn't necessary for the employer to review every possible last piece of evidence, even if the employee has asked them to. The jargon is that the investigation need only be sufficient to come within what's called the range of reasonable responses, which basically means that, yes, some employers might have carried out more of an investigation, some might well reasonably have carried out less of an investigation, but this was a reasonable investigation within the range that's open to a reasonable employer.